many of you are aware, Charlie Kirk was assassinated several weeks ago, unfortunately, and his alleged killer is being brought back to trial. And he's being brought back because there's going to be a hearing. They're trying to figure out what they're going to do before we get to the actual trial. And now we're going to hear from his representation. It seems like Tyler's got representation. We're actually going to be talking about Tyler himself a little bit later, and we'll get into that in another video. But here we're going to hear from the judge. We're going to hear from both sides as far as how they want to handle the preliminary hearings and how they're going to move forward into trial. We may be hearing something coming from Tyler too. Now make sure you stick around and check this out.
Please be seated. Good morning. Court is now in session. Calling the case 251403576, State of Utah versus Tyler James Robinson. Counsel, could you enter your appearances, please?
Oh, by the way, do y'all think Tyler did it? There's a lot of conspiracy theories out here. I want to know in the comments in the chat, what do you all think is going on? If you've been following this at all, I need your opinion, because we're going to cover some of the conspiracy theories about this a little bit later. But who do you think is responsible for Charlie Kirk's death? Is it Tyler? Is it the FBI, CIA, NSA, the governor? Let me know what y'all think.
Chad Grunander, Jeff Gray, Lauren Hunt, Ryan McBride, and Chris Ballard for the state, Your Honor.
Good morning, counsels.
State is loaded and
Good
up.
morning, Your Honor. Kathy Nestor, Michael Burt, and Richard Novak on behalf of Mr. Robinson.
Good morning, Your Honor.
Good morning to you all.
Good morning.
So he's got a team up
Into
there.
the
We'll have to
jail.
research them.
Do we have Mr. Robinson present?
Yes, Your Honor.
All right. Mr. Robinson,
That's
good
Tyler.
morning to you as well. Counsel, as we begin,
Cool, calm, and
I have
collected.
entered orders allowing the admittance of Mr. Michael Burt, Mr. Richard Novak, pro hoc vice, and appointing them along with Ms. Catherine Nestor to be Mr. Robinson's counsel. The court enters findings that the combined experience of counsel meets and exceeds the requirements of Rule 8. Counsel, do we have, what would we like to accomplish today?
I have two items, Judge. I just wanted to make a record that under Rule 16 of the Utah Rules of Criminal Procedure with respect to discovery, the state is required to provide to the defense within 5 days of the defense's request the discovery that we relied on in making this charging decision. We'll be prepared to do that, so we'll
Y'all
look
don't think
for
he did it? Wow.
defense counsel's request or the next day or so, and we'll provide that to the defense.
Thank you.
We also, for the court's information, we met this morning with the defense team briefly in our office to talk about discovery and the process, so we'll be working together. There is a substantial amount of discovery in this case, Your Honor.
A substantial
it's voluminous,
amount.
to say the least.
Wow.
We're working on a process where we can exchange information as quickly as possible and be efficient in that process. The other item I had, Your Honor, I saw that over the weekend there was a
Voluminous, he
protection
said.
order, pretrial and trial publicity order entered by Your Honor. And I just was seeking some clarification. On page 2, at the end of the first paragraph, it reads, "To that end, lawyers participating in the investigation or litigation of this case shall inform all witnesses, investigators, consultants, staff members, or other members of the prosecution or defense teams that the prohibitions contained in this order." The state, we're seeking some clarification with respect to the phrase "all witnesses," Your Honor. There are a number of witnesses that have yet to be identified that will likely be used in the state's case. This
Lance.
occurred in front of 2,000 to 3,000 students at Utah Valley University. So we're in the process of identifying those witnesses. And so those individuals are presently unknown right now. So we're looking for a little clarification from the court. And I suppose we're not going to make any arguments today, but there may be some follow-up pleadings that we may need to file.
Thank you. Ms. Nestor, did you want to be heard about that issue?
No, Your Honor, we would defer to whatever the court wants to advise them on that matter. I mean, I think it's fairly obvious that we don't know who all the witnesses are in this case yet. I think it's just important that if anyone is identified, that they have information about this order. So I think other than that, we wouldn't weigh in on any other matter.
Thank you. Well, thank you for that question. That's an important one. The court will rule that as the witnesses become known to each side, that information is conveyed to abide by this order. Obviously, there are potentially many witnesses, and so it's not the expectation that you would be able to do that up front, but as they become known, I would ask that you would inform them of this. Anything else, counsel?
Nothing from the state, nothing else, Judge.
Thank you. Ms. Nestor.
Thank you, Your Honor. We recognize that
there's
we
a
are here
lot of
today
evidence.
for a waiver hearing. It is not our intent to waive a preliminary hearing in this matter. We are going to be seeking that one be set. However, based largely on what the state just referred to as far as the voluminous nature of the discovery materials, we do think it would be prudent to simply reset for another conference, another waiver hearing, a little bit down the road, where we have a better idea once we start seeing the discovery as it rolls in. I do recognize we're going to be getting that first batch in 5 days, but it's my understanding from our meeting today that there is massive amounts of digital that is going to be coming. And
Like what?
until we can kind of get our heads around exactly what we're dealing with and how much we need to process, it's going to be difficult for us to give you a reasonable expectation of when we will be ready to do the prelims. So we're asking today that we put that decision off, and maybe we could check in 30 to 60 days and just kind of let the court know where we're at and how much we're looking at and how much time we may need to set a preliminary hearing.
That preliminary hearing is going to be
Also, as far as a
insane.
detention hearing, we are not asking the court to address that issue at this time. Under the statute, the issue is going to come down to the question of whether there's substantial evidence, which right now we're just not in a position at all to be able to even argue to the court. So we are probably going to ask that the court delay that decision possibly until the time of the prelim. But if it's sooner, we will ask the court for a hearing. But at this time, we are not asking the court to make any decisions on that matter.
Thank you, counsel. In regards to the next hearing date, how about October 30th at 10 a.m.?
That works for the state, Your Honor. Thank you.
All right.
That's fine for the defense, Your Honor.
All right.
It's 30
Now,
days
as
from
we're
now.
at the beginning, anything further from counsel from either side?
No, Your Honor. Thank you.
No, Your Honor, thank you.
As we are at the beginning of this case, it is my intent to only speak when I'm needed or it is necessary. But today I do wish to provide guidance
This
and
judge is
expectations
super
that you
chill.
can have for this court and wish to enter an order as well. As this case moves forward, Mr. Robinson's constitutional rights will be protected at every stage. He sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. At the same time, and as applicable, victims are entitled under our Constitution to be treated with fairness, respect, and dignity, free from harassment or abuse. Justice demands that both of these principles, the rights of the accused and the rights of victims, be honored without compromise. I remain steadfast in my oath that I made 56 days ago to support and defend the constitutions of the United States and of Utah. I will carry out my duties with fidelity, transparency, and impartiality, treating every person who appears before me with the dignity and respect they are inherently due because they are human beings. Let me be clear. I will not put my finger on the scale of justice.
Shout
These
out to the
proceedings
judge.
will be open to the public, conducted in accordance with the law, and handled with diligence and competence to ensure that justice is never compromised. It is the standing order of this court that Mr. Robinson shall be allowed to appear in person so he can fully engage with his attorneys and participate in these legal proceedings.
Wow.
Counsel, regardless of who is watching, whether it is the nation or a single individual, we must fulfill our roles with integrity, civility, and diligence. I encourage each of you to give your very best to this case. Neither Mr. Robinson nor the people of Utah deserve anything less than the fair and impartial administration of justice. In regards to the next hearing, counsel, on that October 30th date at 10 a.m., it's the court's intent that be in person if it be the wish of counsel for the defense for Mr. Robinson to be present.
It is, Your Honor. Thank you.
Thank you. Counsel, anything else that we can address today?
Your Honor, we appreciate the court's comments with respect to Your Honor's role in this case. In like matter, we commit to approach this case with integrity, with professionalism and civility. We are truth seekers. We will aggressively pursue the truth in this case. Thank you.
Thank you.
We want to know what's going on.
All right, counsel, unless there's anything else, thank you for being here. This court is in recess.
All right, there it is. So shout out to the judge saying, hey, y'all ain't gonna hide. Everybody's gonna know what's going on. Also, interesting fact is that there's so much evidence in this case. Obviously, we know there were messages being sent back and forth, allegedly. There was information about Tyler being at other locations, allegedly. We have all the witnesses, the eyewitnesses, the video that may come out. I mean, there's so much we could get into. So I'm going to be interested to see what this evidence looks like, because y'all know we're facts over feeling here, right? Speaking of, let's go ahead and get into that. We're going to hear a little bit more about what this evidence can show and what we've seen already from the state of Utah in this case.
Kirk's alleged assassin will appear for a virtual court hearing where his legal team will decide if they want to waive the right to a preliminary hearing and speed up the proceedings. Tyler Robinson faces multiple state charges, including aggravated murder, and state prosecutors are seeking the death penalty. Fox News legal analyst Greg Jarrett joins us now. Greg, thanks so much for joining the program this morning.
Sure. Lawrence, good to be with you. You know, I think given the intensity of the public passion surrounding the cold-blooded assassination of a beloved figure, I think the concern right now today is safety and security. It's unwise to run the risk of an open courtroom appearance when it's not really necessary for a fairly routine court appearance known as a status and waiver hearing, as you point out. So they're going to have the accused on videotape from jail instead of in the courtroom. You know, the judge will talk with counsel about the track of the case, sharing evidence, whether the defendant will waive his right to a preliminary hearing. You know, but you don't really need Robinson there in court. Plus, you avoid the negative optics, the accused in shackles that might create undue bias in the minds of potential jurors if seen in photographs and videotape. So you're not going to see him there literally in court today, only by videotape, and there are good reasons for that.
So let's talk about this appearance and the mountain of evidence. So he's been appointed a public defender.
That's what I want
to
hear
this
about
public
too.
defender is very skilled, has a lot of experience. But then I look at the mountain of evidence against him. So there's a note where he talks about, I had the opportunity to take out Charlie Kirk, and I'm going to take it. There's DNA matches on the rifle and the trigger, spinning unused cartridges casings. And then there's the towel rifle that was wrapped in. Then you got the family interviews, details his shift from left-leaning to pro-gay and trans.
Now, we're going to get into this about the family shortly, because we're hearing this report from a lot of sources, but in this instance, Fox News is saying that about his family's, Tyler's relationship with his family. Candace Owens has her own source, and she's hearing something a little bit different. Again, you guys be the judge. You let me know what you think. I personally think there's so much more to this than we know. And if we're going to hear details from the family in this case, you're going to have to decide or make a decision. Is this something they were pressured to say, or is it the truth based on the facts that you see?
It's gender beliefs. So you got motive, you got evidence to support it, and that doesn't even include the text messages as well. We've went over that. What can she do to defend him when she has this mountain of evidence that she's going to have to deal with?
Mm-hmm.
You're absolutely correct. The evidence is powerful, it's compelling, it's formidable, but there are 3 court-appointed defense counsel in this case. That's required by law. They're vastly experienced in death penalty cases. Make no mistake, they will challenge the admissibility of all of the evidence you have recited. In the end, I suspect they will not succeed. I think their ultimate goal is to save their client's life. And, you know, this case uniquely presents a moral quandary because the victim, Charlie Kirk, believed passionately about charity and love and understanding. He embraced mercy and forgiveness. And I think the defense will probably try to argue that in a penalty phase if it gets to that point. And it will be hovering over the courtroom regardless in the minds and the hearts of the jurors. Is it morally correct under these circumstances to put somebody to death? I mean, look, personally, I've long been against the death penalty for moral reasons. I understand that the Supreme Court has upheld capital punishment. But this case, I think, presents, as I say, a moral dilemma for these jurors that is unique in this case above all others.
So real quickly on that, you know, sometimes in negotiations, you need to give the state something, especially if you want to take the death penalty out. Now, it doesn't look like they're going to do that.
I don't think that's
there has
gonna
been
happen.
Speculation, and even
in my opinion, the only way they would take the death penalty out is not if this were to go to trial. The only reason they take it out is if there were some sort of plea, and I don't even see the state of Utah offering him a plea. Not in this case. Like, this has to go to trial for so many reasons.
FBI director has talked about these chat rooms. If this suspect was willing to give up people that are in these chat rooms and there's credible evidence, could that possibly be something that the state is interested in?
Mm-hmm.
Yes, absolutely. It could be. And a plea deal is always a factor. We obviously saw it recently in Idaho in the Brian Kohlberger case.
That's right.
They did it for a variety of reasons. So the one you state could be a consideration, but the other might also be the wishes of the family of Charlie Kirk, the deceased, the victim in this particular case, for the moral reasons that I just stated. I can't speak for him or his family, but the thought has crossed my mind. So a plea deal is always a possibility. And, you know, as the great Clarence Darrow once argued, in the famous Leopold and Loeb case, it is a far worse punishment to be locked up, caged like an animal for life, than the easy exit of death.
Well said. We're going to end on that note. What do you guys think? We saw the hearing. We know what Tyler is facing. How is this going to play out? We're going to see a lot of the evidence in these preliminary hearings. Definitely looking forward to that. Y'all know we will cover it here, and I'll be interested to hear specifically from the people that were involved with Tyler, not just some people, specifically his family, possibly hear from Lance, the roommate. I mean, there's so much that will be heard, and we're going to get an update there coming up on the 30th of October. Y'all know we'll be here for it. Let me know what you think in the comments and in the chat.